Eric Prichard. Eric's a graduate of Claremont McKenna College out in California. His law degree is from right in the area at Boston College Law School. And Eric works with 4 main areas in law. One is estate planning, probate, elder law, and special needs planning. Eric actually is known nationally for the work he does in special needs planning and elder law. So we're very privileged to have him with us today. He's going to talk you through just all the current laws up to date to 2021, all the current state laws in Massachusetts. It's also a fantastic time to get your questions answered. If you want to put a question in the chat, Maria and I will take those questions and work them in. If you have a question that's a little sensitive and personal to you, you can send that privately to me or to Maria, and we'll put that question in anonymously for you. So without further ado, Eric, we look forward to what you have for us today, and thank you for being here.
Thanks, Bill. I appreciate it, and I'm really happy to be here today to talk to you guys about estate planning. Before we get started with the meat of the presentation, I think it's always really important to remember that a bunch of the things that we're going to talk about today are things that you folks can probably do on your own without a lawyer. There's nothing in the law that says that you need to have a lawyer draft your will for you or do your healthcare proxy for you or change things around financially for you. And I'm here to tell you not to do that. Not just because it's good for my business, but because when you start making changes on these documents or playing around with your finances without running it by somebody who knows what they're doing first, you can really mess up the whole plan very quickly sometimes. And so seemingly simple things that you do with your financial affairs could have huge ripple effects for your entire estate plan. So it's really important to work with an attorney on all of this stuff, even if you think it's going to be minor, or even if you think that the questions are silly. It's always a good idea to run it by your lawyer first. So when we talk about estate planning, there's a lot of different aspects of estate planning that we could get into. And we're going to focus on a few reasons why you want to do an estate plan today. The first is control. When you put together an estate plan, you're the person in charge of things. So you get to choose who runs your estate, who manages your affairs. And that helps avoid guardianship if you become incapacitated. So you're in the driver's seat. It's not a court, it's not relatives you don't like, it's you. The second reason folks will do estate planning is for security. So there are 2 aspects of this. The one that everybody always thinks of is your family, right? If something happens to you, who's going to take care of your family? Where's the inheritance going to go? But honestly, primary for me is making sure that you are taken care of if you become incapacitated. And that's a key component of estate planning, is making sure that we have documents in place that will allow the people we choose to take care of us if we can't make decisions for ourselves in the future. And then the third reason people do estate planning is convenience. If you do the planning, you're going to reduce hassles down the road. That's the whole point of doing planning. If you don't do the planning, it tends to be more complicated. You can also save money on taxes, and then we'll talk about taxes near the end today when everybody's tired of hearing me. And you can save a lot of money on legal fees. So even though often you're spending some money with lawyers up front to put this plan into place, it's a lot cheaper than doing it, not doing anything, and then I have to fix the mess. So a little bit of money up front saves a ton of legal fees down the road if you put the plan in place. So lots of reasons to do estate planning. For those of you folks who haven't gone through an estate planning process with an attorney before, what generally happens is we'll get together, we'll sit down with the clients. Nowadays, we're doing everything remotely, but hopefully soon we'll be back in the office face to face. And we chat. We talk about your family. We talk about your plans for the future. We talk about your finances and kind of get a picture of who you are and what your family looks like and what your finances look like. And once we have that picture in place, we can develop a plan for you. And at the end of that process, it's going to boil down to paperwork. the plan turns into a set of documents. And now it's more complicated than that, but it boils down to these things. And these are the 5 essential documents that most people will have some kind of contact with over the course of an estate plan. The first one is a healthcare proxy and living will. And a healthcare proxy is probably the most important one of all of these documents. And it's also usually the most straightforward one to put into place. With a healthcare proxy, what you're doing is you're naming somebody to make medical decisions for you if you can't make them for yourself. So you're literally just picking a person to step into your shoes and tell doctors, nurses what to do if you can't verbalize that to them. The living will, which people often confuse with a healthcare proxy, a living will is where you give instructions to those people about what you want them to do for you. So that's the part that everybody always thinks of, where they think about do not resuscitate or keep me alive, treat me with this stuff, but don't treat me with that stuff. That's your living will. It's separate from a healthcare proxy. Often it's in the same document. So Brown and Brown, we put those things together. But in reality, the important one is the proxy, because that's the document that gives the person the power to actually step into your shoes and communicate for you. The living will in Massachusetts is good for instructions, but it's actually not even legally binding here. So if you write down all these complicated things about what you do and do not want to have happen, no doctor or nurse is reading those forms. They're not going to follow your directions. They're going to do what the healthcare proxy tells them to do. And so it's really important that you have that in writing so that your agent knows what to do for you. And hopefully you've talked about that with them. But at the end of the day, it comes down to the selection of your agent to help you through those difficult times. So that's healthcare proxy, and every adult should have a healthcare proxy. The second document on this list is equally important, and that's a durable power of attorney. And what you're doing with a durable power of attorney is you're essentially naming a person to step into your shoes and manage everything else about your life other than healthcare. So it's frequently, paying your bills, gaining access to your financial accounts, but it's much broader than that. So a person with a power of attorney can go get your mail, they can sign contracts for you, they can sue people for you, they can get into your 401ks and manage the investments. It's a very broad power, and folks rightfully get a little worried about it, saying, well, I don't want to give somebody all of that power over me. But the problem is that if you don't put that in place, and if you don't name the person who you want to do that for you in that document, if you become incapacitated, we have to go to court to gain control of those things. So if you're on a house, and even if you're on a house, let's say with your spouse, and you're incapacitated and your spouse wants to move, we need 2 signatures on that deed. The spouse can't sell the house on their own. And if you can't sign the deed, how do we sell the house? Well, if you have a power of attorney, that's easy, because the agent on your power of attorney can step in and do that for you. But if we don't have a power of attorney, we've got to go to court, get a conservatorship, which can take months, and then get court approval of everything that we're trying to do. And that's just a horrible, unwieldy process that most people would rather avoid. And again, you don't have control over that process if you're incapacitated. So putting together a power of attorney where you're picking the person who you think is appropriate for the job is really much more powerful than sitting around and waiting for something horrible to happen and hoping the courts will take care of it. So those 2 documents, the healthcare proxy and power of attorney, are kind of must-have documents that everybody needs, regardless of their financial situation, regardless of what they want to do with their estate plan. The third one on this list is a declaration of homestead. And frankly, most of you who own homes probably already have this. A declaration of homestead is a piece of paper that gets filed at the Registry of Deeds that says that your house is your primary residence. It's a very simple form. You often do it when you buy your house or when you do a mortgage. It'll get kind of thrown in there by your closing attorney. And what it does is it prevents creditors from throwing you out of your house to satisfy a debt. So if I got sued and the creditor's coming after me, if I don't have a declaration of homestead on my home, they could force me to sell the house in order to pay off the debt. But with a declaration of homestead on the house, they're not allowed to do that. And so I'm able to stay in the house. I'm not going to be kicked out onto the street. Doesn't mean I still don't owe the money. I do. And if I pass away, they'll be able to come after the house at that point and get it. But while I'm living in my primary residence, they're not going to be able to remove me and get into the house. So it's really crucial that you have one if you're a homeowner. You can only do it on your primary residence though. So if you got the vacation house down the Cape, you're not going to usually homestead the vacation house. You're going to put it on the house where you live most of the time. Same thing if you own out-of-state property. That you're not going to homestead an out-of-state vacation home. You need to do it on your primary residence. So those are three pretty straightforward documents. The final part of this, the wills and the trusts, are really what we're going to spend the rest of this conversation talking about today. Not that they're more important than the other ones, but they're more complicated than the other ones, and so it takes a lot longer to explain what they do. Before we get into wills and trusts, though, we have to talk about this concept called probate, because all this ties into the concept of probate. And probate, as you can
Eric,
see,
can I interrupt you one second? I'm sorry, because we had a question come in on homestead.
Yep.
And I don't want to get too far beyond it. If homestead is declared and one person dies but leaves the home in a trust or identifies it in a will, can a creditor still come after the home?
Typically, yeah. So if I'm single and I had a homestead on my house and I die, and if the house passes through my estate, a creditor can certainly come after my estate. If it's in a trust, it's a little bit harder for a creditor to come after a trust. And depending on what kind of trust it is, maybe impossible. But there are ways for creditors to get into trusts as well. So the homestead is really designed to protect the house while the person is living in the house. Once the person isn't in the house anymore, either because they passed away or because it's not their primary residence anymore, all bets are off when it comes to the creditors coming after the house.
And just a quick follow-up, how do you know if you have a declaration of homestead? Is there a document or?
Yeah, so you can go online at the Registry of Deeds in the county where you live and search for it. That's all that information is publicly available. You can access it on the Registry of Deeds website. And if you know how to fill out the forms properly on the website, you'll find it if you have it. It's not always so simple because there's multiple ways you can register land in Massachusetts. And if you don't know where your house is and how it's registered, that can be tricky. But it's public record. So if you know how to use the registry website, you can find it there.
So we've hit a hot topic here. If the home is under two names, does it require a declaration of homestead?
Yes, absolutely does. Back in the day, you only used to have one person file the homestead. So if you were married and you didn't have both names on the homestead, you picked a spouse and that person signed the homestead. So if you were under the old system, and that goes back, probably about 12 years now, that's how it used to be. Nowadays, it's both. So you both sign the homestead. If you were under the old system, you don't have to convert to the new system. But if it was done in the last, say, decade, you're going to want both signatures on the homestead because that's what the new rules say.
Very good. Thank you.
All right. And keep the questions coming. We'll go over them as we get them, obviously. So getting back to the probate concept here, when we're talking about probate, what we're talking about is court supervised distribution of assets when somebody passes away. And the key thing to keep in mind here is that it's court supervised. And in Massachusetts, court supervised means slow. Even pre-COVID, courts weren't very good at getting things done quickly with probate. And so it tends to be a slow, kind of unwieldy process. When you pass away with a will, without a will, the procedure for probating an estate is fairly similar. There are differences that come up when somebody passes away without a will in terms of how difficult it is to do certain things, like selling real estate. If you don't have a will, is a lot harder through probate than if you have a will. But in general, the forms that you're filling out, the concepts are fairly similar if you have a will or you don't have a will and you're going through probate. But Here's the key concept about probate that I think you have to keep in mind, is that not everything that you own is actually governed by the probate court system. So the things that are included in your probate estate if you pass away are anything that somebody owns individually in their own name, without a designated beneficiary, without a joint owner on it. So here's a couple of examples, right? If I have a house in just my name and nobody else is on the house with me, and I pass away, that house goes through probate. If I've got a bank account or an investment account, or those stock certificates that I got when I was 20 years old and I just threw them in a drawer, the savings bonds I've had since I was a kid, just in my name, those are the things that go through probate. That could be cash, that could be artwork, lots of different things could have to go through probate. But the important thing
Eric?
is that there, yeah.
We also got another question in regards to what about two different names before official marriage? So if someone goes by two different names?
The names don't matter. That's the easy answer. You can
Okay.
always AKA something. So if I did a homestead and then my name changed because I got married, the homestead's still valid.
Okay, thank you.
Yep. So the stuff that's not included in the probate estate is actually usually more important than the stuff that is, because things that you own jointly with another person, things that have transfer on death, payable on death, in trust for designations, accounts with named beneficiaries on them, and things held in trust generally don't go through the probate process. So if I pass away and my bank accounts are all joint with my spouse, and I've got people named as beneficiaries on my IRAs and my life insurance, there might not need to be a probate when I pass away because I might not have anything that's in my individual name. All those other things trump the probate system. So the only stuff that's going through probate is stuff that's in my individual name that doesn't hit one of these criteria that you see on these slides. And that could be a lot of stuff, or it could be nothing at all. It really depends on the situation. So when you have a probate, the will is what controls your probate property. And the will only controls the probate property. So I could have a will that says, if I'm gone, split my estate between Bill and Maria, right? But if my entire estate is joint with my wife, or names my wife as the beneficiary and everything, Bill and Maria are getting nothing because there's nothing that's going through the probate court system that the will would direct. The will is only controlling probate assets. And so when you're doing your estate plan, it's really important to keep in mind that the beneficiary designations, the joint ownership, the will are all interact together. And that's why we don't want to play with things. Because if I change the joint ownership to name somebody as a joint owner, then the will says something else. The joint owner gets the joint stuff and the will does what it does with the other things. So it's really important that you coordinate all of these things together. The will does allow you to control those probate assets though. So you can direct where the probate property goes through your will. That's the whole point. It also allows you to choose who manages your probate estate. So that person used to be called an executor, but it's been called a personal representative for a long time now. So you get to pick who is in charge of the probate process for you. If you have minor children or if you have adult children who are under guardianship, the will is where you pick the person who will take over and take care of those kids if you're gone. So the will is where you name the guardian for your minor children or your adult children who are incapacitated. But as I hope you've figured out as we've talked about this, wills don't avoid probate. So I have people all the time who come in and say, well, my stuff's not going to go through probate. I have a will. That's not what a will does. A will distributes your probate property. It says who gets your probate property. It makes the probate process a little bit easier, but it does not avoid probate. There are other things that we're going to talk about that avoid the probate court system, but a will is not one of them. The will distributes anything that has to go through probate. So just because you have a will does not mean you're staying out of the probate court system. It's just going to control that whole court process. It's much better than nothing because it allows your wishes to be carried out and it allows them to be carried out more efficiently. But but it does not keep us away from the probate court system.
Eric,
Yes.
we have a quick question. So when we speak about estates, does that include a car? So if someone has a car that's jointly owned and registered, can they avoid probate? I think you
So
answered
if
a
it's
little bit.
jointly owned, the answer is yes, because it's joint. And so joint ownership avoids probate, as we're about to talk about. But cars are interesting in Massachusetts. So if you're married, often you won't have the car in both names. It's whoever went to the RMV, whoever financed the car might be the only person on the car. And so when you have a married couple and only one person owns the car and that person dies, the surviving spouse is allowed to go to the Registry of Motor Vehicles and transfer title of the car over to their name without having to go through the probate court system. Where it becomes a problem is if you're single and you pass away with a car. The car is a probate asset. It's not jointly owned. It's just in your name. That would go through probate. If it's only a car that's going through probate, and we don't have a significant probate estate outside of the car, you can actually file something called a voluntary administration statement in Massachusetts. And that's for probate estates that are worth less than $25,000 and include a car. So the car doesn't count towards the $25,000. And you list the car on there, you put the VIN number on, the year, make, model, and you list all the other probate assets so long as they don't add up to more than $25,000. And you file that at the Registry of Deeds and the Registry of Probate, and the Registry of Probate will stamp it and give it back to your personal representative. And then that person takes the form to the RMV and can deal with the car. So it's not, you don't have to go through a full-on probate for just a car. You can just do the voluntary administration statement. But if you're married, you don't have to do any of that. You just go to the RMV, you fill out their paperwork, and they'll give you the car. Long answer to a short question. So obviously, a big part of estate planning is trying to figure out if and how we can stay out of the court system. And there are lots of ways to do that. And you've probably deduced these from what I've been talking about already. The first one is joint ownership. So if you own an account with another person, or you own a piece of property with another person, there's no probate when the first joint owner dies, because the surviving owner is still an owner. They still control that asset. And it allows you to have maximum access to those accounts because you share them completely. There's no restriction on any of the joint owners doing anything with them. So I could take out all of the money out of an account I own jointly with somebody else without the other person's permission. But the problem is, there's a couple problems. One of the problems is that when the second owner dies, so I'm gone, now my wife owns the account, there's no more joint owner. So now when she passes away, that's going to be a probate asset because it's in her individual name. And unless she does other work, it's not going to avoid probate on the second death. And then there are other interesting things that come up all the time with joint accounts that affect families, especially when we're not talking about couples. So I'll give you a classic example where you have a parent, a single parent, who has 3 adult kids and wants the adult kids to share everything equally. But one of those 3 kids is the one who's local and helps the parent out with the bills and you know, all the stuff that they do. And so the parent puts that kid on the bank account as a joint owner because they want them to be able to cut checks and see what's going on with the bank account. When the parent dies, because it was a joint ownership, the kid who was joint on the account gets the account legally. It's theirs. It's been there since the parent made them a joint owner. The other kids get nothing. And if the parent's done that on multiple accounts, you could end up in a situation where, yeah, you avoided probate, but now you got one kid who owns all of it. And that kid is not legally, required to share it with their siblings. Now, often they will, split it up and distribute it. But there are lots of situations that come up where it's not so easy for that kid to do that. So that kid who's on the joint account is going through a divorce. Do you think the divorcing spouse cares that the kid wants to share it with their siblings? No, they're going to take half the money. If the kid is being sued and creditors are coming after it, they don't care. They're going to take half the money. Or you could just have a kid who doesn't want to share it and they're not under any legal obligation to do that. So when you go outside the system and you think, oh, I'm going to make this easy on everybody by naming this kid as a joint owner, it doesn't always work out that way. The other problem is while the parent's still alive, if the kid's a joint owner on the account and the kid gets sued, the creditor's coming after that account because the kid owns it. And the creditor, the divorcing spouse, does not care that it's not really the kid's money. The kid was on it, they own it, it's theirs. And so you can have a situation where the parent did nothing wrong and the kid gets into trouble, and now the parent's money goes out the door. And I've actually sat in the probate court watching a father testify in a divorce case that, yeah, he put his son on the house, but the son, it wasn't really the son's house. And then the son's spouse who was divorcing him was coming after the house because it was in the kid's name. And you don't really have a very good way around that because legally that's the name on the account, that's the name on the house. So it's really important before you start adding people on as joint owners that you consider all the ramifications of doing that. It could work really well when you have couples, but it doesn't always work so well when you're getting into other kinds of relationships. So a solution to that problem is to use beneficiary designations on accounts instead. Things like transfer on death benefits, TOD, POD, in trust for. These are all variations on the same thing. And what you're doing there is you're naming beneficiaries on the account who get it after you're gone. So they don't own it now. It's not a joint ownership. So if they get into trouble, their trouble doesn't come after your account. But when you die, the account will pay to those beneficiaries who are named as transfer on death, payable on death, in trust for, and it won't go through the probate court system. So that's a simple, efficient way to get things out to beneficiaries, as long as it's okay for the beneficiaries to get money. So you generally don't want to transfer on death an account for a 5-year-old, because then you got a 5-year-old inheriting the money, and that's going to cause directly, and that's going to cause some problems. You don't want a TOD in account if the adult beneficiary has special needs and is getting SSI, because now they're going to inherit it and it's going to mess up their benefits. So again, this is one of those things where people do it a lot without thinking about how it's going to end up working out. You want to make sure that there aren't any issues when you name a person as a beneficiary, because once you're gone, the money dumps out and the money is gone. But it could work really well if it's a plain vanilla situation. Adult person, no financial problems. It's easy to do these things and avoid probate. Yeah.
Oh, we have a couple of questions coming through. What is the tax liability on the joint item if one spouse dies and if they are a non-resident alien?
That could be an entire seminar. We'll talk about estate taxes at the end, but the key is that if you transfer an account to a spouse and they're not a citizen, that could potentially be subject to estate tax, state and federal estate tax. Whereas if you're transferring an account to a citizen spouse, it's not. So that's the short answer, is that transfers to non-citizen spouses are not estate tax exempt. And so it could be part of the estate depending on how big the estate is.
Thank you.
There are ways around that, but the basic answer is it could be subject to estate tax.
And then the next question is, could a trust operate to pay bills, etc., and then protect the assets from divorce, being sued, etc.?
Yes. It's harder to do that. So it depends on who you're trying to protect. And we'll talk about trusts in a little while too, but in general, most revocable trusts that belong to the donor don't protect the donor from those things. So if I set up a revocable trust in my name and I fund it and it's my trust and I can change it whenever I want, it's not going to protect me from creditors. It's not going to protect me if I get divorced. But if the trust is set up so that when I'm gone, it holds the assets for my kids. And if it's set up properly to do that, it will protect the assets from the kids' problems. Which is typically what people are doing with these things, is they'll structure it to avoid problems in the kids' names. Not all trusts do it that way. I mean, you have to structure it that way on purpose, but you could definitely set up a trust to protect the beneficiaries from those issues. If you want to protect yourself from those problems, you generally have to give the asset away and put it into a trust you're not in charge of. And you have to do it in advance of the problem. So you can't say, oh, she filed for divorce on me yesterday, I'm going to dump all this stuff into an irrevocable trust today and she's not going to get a dime. It doesn't work that way. If you get into an accident and you know you're going to get sued, you can't just fund your irrevocable trust and avoid the lawsuit. You have to do it in advance where it doesn't look like you're hiding the money. So that's the short answer to that.
Thank you, Eric.
Yep. So, I mean, the big takeaway from the beneficiary designation question here is make sure you check the beneficiary designations. You know, I have people who set up their 401ks when they start at a job and they've been there 20 years and their whole life has changed. You know, you'll find that you've got an ex-spouse on the beneficiary designation. You'll have parents, and now you're married with kids. So it's really important that at least once a year you go in and you just make sure that your life insurance, your retirement beneficiaries are who you want them to be. Because it happens all the time that you don't update things, and then you have big problems if something happens to you. So make sure that you do that. So moving on from the simple things we can do, joint ownership, transfer on death benefits, things like that, we get into these trusts. And there are tons of trusts. It's really hard to generalize about trusts because there's so many of them and they're so individual. But basically what you're doing with a trust is you're creating an entity that's designed to hold your assets while you're alive and then manage them after you're gone. And trusts are more efficient than probate because they don't go through the court system, and typically provide more protection because you can do these things we were just talking about. You can structure them to make sure that beneficiaries don't gain access to money they're not supposed to. And some trusts allow us to do other things like protect money from estate taxes and Medicaid liens, and we'll talk about that in a second. And again, there are so many kinds of trusts and they have so many different names. I mean, a lot of attorneys have these ridiculous names for trusts to make them sound fancier than they actually are. You know, like the Prichard Family Dynasty Protection Trust, or it gets ridiculous. But in general, they kind of boil down into a couple of different buckets. You've got revocable trusts, which are the typical trusts that you see in estate planning for most people. You get credit shelter trusts, which are revocable trusts on steroids. And they're really designed to protect against or to reduce estate taxation. And then you have irrevocable trusts, which for the most part are used to avoid long-term care costs. Sometimes they're used for tax purposes too, but for the most part, we're dealing with Medicaid. And I unfortunately can't get into huge detail on any of these, but there are a few things to keep in mind. Revocable trusts belong to the donors. That's the whole point. A revocable trust can be changed by the person who sets it up. So you're not giving anything away when you create a revocable trust. It still belongs to you. The reason you're setting up a revocable trust is to keep things out of probate, because if you put things in a revocable trust, they don't go through the court process, and then to manage them later. So if you have a family with young kids, you frequently use a revocable trust to make sure that the money is held for the benefit of the kids if something happens to the parents until the kids are much older. Sometimes it's just probate avoidance. So you get families who they have adult kids, the adult kids are fine, there's no problems with money, but they really don't want to have to go through the probate court process. So they'll set up a revocable trust just to make sure that it's easy for the kids after they're gone. They're not trying to do anything fancy with management. But the key thing about revocable trusts is that they can be changed. They're accessible to the donors. And so they don't offer the donors any protection from creditors. They don't protect your stuff if you need a nursing home. They're your money. You haven't given up control. And because you haven't given up control, people coming after you can come after the trust. So they're really probate avoidance tools, asset management tools for other people, not used to take care of you if you need those things. The credit shelter trusts, I'll show you at the end how those work. They're revocable trusts, but they have some bells and whistles that help us kind of cut down on Massachusetts estate tax, and I'll detail that in a minute. But for all other purposes, they're still revocable. They still have the same qualities as any normal revocable trust. The irrevocable trusts are the ones that cause people the most grief because I think they're the least understood. And they're the ones that you hear about on the radio all the time. You know, protect your assets from a nursing home. You can still be in charge. Blah 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 blah. That's not really very accurate. Irrevocable trusts, as the name implies, mean that you cannot change them once you've set them up. They're irrevocable. And so if I create an irrevocable trust and I put my house into an irrevocable trust, the house doesn't belong to me anymore. I've given it away. That's the whole point of doing this, is you're trying to get things out of your name so that if you need a nursing home down the line, the nursing home or the state, if you're getting Medicaid, can't come after the house, or they can't come after the money because it didn't belong to you. And there's a 5-year look back on transfers into trusts like this. So if I were to fund an irrevocable trust today, I won't qualify for Medicaid benefits for a nursing home for 5 years from the date that I fund the trust. But the problem with these is that they're completed gifts. You've given up control of the asset. And oftentimes what happens is the parent sets up the trust, they dump the house into the trust because they think that's the way to protect it. And nobody warns them that they can't get the money out ever again. It doesn't belong to them. So if my house is in the trust and all of a sudden, you know, I've made it through my 5 years and now I'm starting to decline and I want to move to an assisted living facility. I don't need a nursing home. I'm not at that level of care. I just need to get out of my 3-story house and move into someplace that's more suitable to me. And I need that home equity to buy my way into assisted living. You can't do that because the irrevocable trust specifically says that the donor is not entitled to the principal of the trust. They can't take the money out of the irrevocable trust and spend it on themselves. It's locked in there. You gave it away when you funded the irrevocable trust. You might be able to purchase a new house. So if I want to downsize and I go from that big house to a condo, it's one level, the trustees could sell the one house, purchase a new house, keep it in the trust, and I can live there. But if you're going into a situation where you need monthly rent or you need a big entrance fee and that money is going to come out of the trust, it can't be used for the person who set up the trust. And so you run into problems all the time where the parent set up the trust 15 years ago and now they need to do something with it and you can't move the money around and they're stuck. So they're very useful devices, but you have to be very, very cautious about how you use them and how you set them up and what you have in reserve to make sure that you'll be taken care of if you fund an irrevocable trust, because I see it happen all the time where people do it and then they're left with not enough to take care of themselves when they get older and they don't need the nursing home that they're worried about. So yeah, Bill.
Couple questions come in on that, Eric.
Yep.
In an irrevocable trust, could a personal representative distribute funds to the donor if the trust allows for that?
So the person who runs a trust is not called a personal representative. They're called a trustee. So that's just semantics, but it's important. If an irrevocable trust allows the trustee to distribute things to the donor, then it's not going to protect the stuff in the trust from Medicaid. So yes, you can create an irrevocable trust that does that, but there would be very little reason to do it that way.
Okay. And does an LLC work like a trust that then protects the assets as well as having some access?
So an LLC is a company, and a company, the reason most people set up LLCs is to protect for liability purposes. So if I have a rental property and it's in my name and my tenant sues me, they're going to come after everything that I own because the property was in my name. If I had put the rental property in an LLC and the only asset in the LLC is the rental property, if the tenant sues me now, the only thing that they're going to get in the worst case scenario is the property that's in the LLC. They're not going to be able to breach through that firewall and get at my personal assets. So we use LLCs a lot for liability protection, especially with rental properties, because it shelters the rest of your assets from the problem. As a Medicaid planning device, it really doesn't do anything at all. I mean, if you own an LLC and you're the owner, that LLC belongs to you just like any other asset does, and you're not going to qualify for Mass Health while you own it. So it's really designed as kind of a firewall between you and the asset that could cause you problems. So they're
Okay.
very handy, but not in a Medicaid context.
So a couple more questions. One's a clarification on the first question. If the irrevocable trust gives the trustee discretion to make decisions without specifying the donor, then could the funds be distributed to the donor by the trustee?
So if the trust says that the trustee can give funds to somebody else, the trustee could do that, and then that other person could transfer the money to the donor. But Mass Health will catch you if you're doing that frequently. Because
Or even if they transfer back to the donor directly?
Well, that's how we get out of these problems. So sometimes
Okay.
you need to do that. So
Yeah.
let's say that I have a house and I put it into the irrevocable trust, and the house is my only asset. And then 2 years later, I need a nursing home. So I haven't made it through the 5-year look back period, and I need that nursing home. What you can do is you can convey the house out to some other beneficiary. The beneficiary will then give it back to the donor, curing the transfer, and that would allow me to qualify for Mass Health. Now they're going to come after my house, but at least I can get Medicaid. So that's kind of your escape clause. But where it does not work is where you're doing it as some kind of shady maneuver to have your cake and eat it too. So if I've got $500,000 in this trust, and every month the trustee gives that money to one of the beneficiaries, and every month my assisted living bill is paid by that beneficiary, Mass Health figures that out very quickly.
Okay.
So it doesn't work that way. But if you have to correct problems, it's a way to reverse things.
So we're kind of switching back and forth between two things, but
Yeah, that's fine.
would you suggest withdrawing equity from your home before putting it into a trust?
That is something that sometimes people will do with an irrevocable trust. I mean, for a revocable trust, you don't need to do that because it belongs to you anyway. The problem with one of the problems with irrevocable trust is it's really hard to get or keep a mortgage on it. So you could pull the equity out, and now you've got a loan on it. Theoretically, transferring the property into the irrevocable trust at that point violates the terms of your mortgage, and the bank could call the mortgage due at that point. They frequently don't, but if they catch you, they have the right to do that. If you've put the house in the trust before you need the money and then you try and get the loan, it's almost impossible. However, if you're looking to get a reverse mortgage, and if the trust is properly worded, you could put the house in an irrevocable trust and still qualify for a reverse mortgage if you're going through the right lender. Reverse mortgages are not wonderful products, but if the trust has a right of occupancy and a few other things, you could structure it so that you could still qualify for a reverse mortgage and get equity out. But it's tricky.
So in the interest of time, I'm going to ask this last question and then back out.
Okay.
But is there any instrument that fully protects assets family
No.
at all?
I mean, for a donor, if you create an irrevocable trust and you put your assets into that well in advance of the problem, the asset could be completely protected. So if I took my house and dumped it into an irrevocable trust and 10 years later I got sued, the asset probably won't be attached in that situation. But otherwise, no, there's nothing that's perfect. Often people are only setting these up when there are problems and it doesn't fully protect it. If you have the flexibility to fund an irrevocable trust, and it'll work really well for Medicaid purposes. I mean, you get the house out, you wait your 5 years, you'll qualify for Medicaid, they won't get the house. But it has to be the right situation where you don't need the equity. And a lot of people do. If you can finesse it where, I put my house in here, but I keep $500,000 over here to pay for the next 5 years, then great, it'll work. It's just a lot more complicated than I think a lot of people think it is when they set it up and they say, I threw it in there, I'm safe. And that might be, but when all these weird things come up, you run into all sorts of problems with it. So I guess the lesson here is just be very, very cautious and make sure that the attorney that you're working with who's setting this up is not one of these people who's just trying to sell you an irrevocable trust because they can charge you to do it. But you really delve into what are the pros and the cons of this before you commit, because once you do, it's really hard to reverse it. I think that's the takeaway there. we can do this slide real fast because this is just, the stuff you can put in a trust, which is basically everything. Investment accounts, brokerage accounts, bank accounts, real estate, life insurance, businesses. The one thing that doesn't go directly into a trust while you're still alive is a retirement account. So you can definitely name a trust as a beneficiary of a retirement account. And that happens all the time. I don't want my kids to get my retirement account if something happens to me because they're too young. So I've named the trust as the beneficiary instead of my kids. And that way the money will pay into the trust and can be managed for them. The trust doesn't own the retirement account. I still own the retirement account, but it will pay the trust as a beneficiary, which is the important part. But virtually anything else can be named as owned by the trust. But with retirement accounts, you have to be a little more careful about that. So last but not least, and a couple of questions have touched on this already today, we're going to talk about estate taxes. And the estate taxes are super confusing because often people think it's a tax on the person who's getting the money after somebody dies. And that's not exactly what it is. The estate tax is a tax on the person who passes away. It's a tax on me, my assets, when I die. That's who's being taxed. Now it's going to come out of the money that my beneficiaries are going to get. So in effect, it's coming out of the inheritance, but it's not a tax on the recipient of the money. It's a tax on the person who dies for being over the estate tax threshold. And it's paid out of my estate. It's not directly paid by my heirs. It's not like an income tax. So when somebody receives an inheritance, if I left Bill $1 million, he doesn't pay income tax on his $1 million. My estate might pay estate tax on that $1 million, but Bill's going to get the money free and clear. And then there are two estate taxes that you have to worry about. There's the federal estate tax and the Massachusetts estate tax. And if you're lucky enough to have a large enough estate, you could end up paying both of those taxes. Although, as you're about to see, it's hard to pay federal estate tax because while our Massachusetts estate tax threshold is $1 million, the federal estate tax threshold this year is $11.7 million. So unless you have that kind of money, you're not going to have to worry about the federal estate tax. And as a couple, actually, federally, you're allowed to combine those together. So you're at $23.4 million before you actually pay federal estate taxes as a couple. But Massachusetts has $1 million estate tax threshold. And that snags a lot of people because a lot of things trigger the tax. The tax is on everything that you own at the time of death. I'm just checking to see if there was a slide there that I think I took out at some point. Everything that you own is subject to the estate tax. Anything that you have any control over is subject to the estate tax. So that includes cash, retirement accounts, other investments, bonds, the value of personal property, real estate. It all gets added up together. And that includes almost always the death benefit from life insurance. And that's the one that people don't always understand because they think life insurance is tax-free. And it is, it's income tax-free, but it's not usually estate tax-free. So if I have a life insurance policy that's $2 million term policy, not a lot of cash value, and I die, I have a $2 million estate for estate tax purposes, even though I might not own anything else. In Massachusetts, I'd still be subject to the estate tax because it all gets added up. So we're looking at everything that the person owns when they die. However, and this gets back to that question that was asked, a while ago, there are certain transfers on death that aren't subject to estate tax. The most important one is transfers between spouses. So if you transfer, if all of my money goes to my citizen spouse, there's no estate tax on that, no matter how much money that is. It could be $1 billion. There will be no estate tax when I die and that money transfers to my spouse, as long as that spouse is a citizen. Now, when my spouse passes away, she's going to have all of that money, plus all of her money, and that will be passing on to our kids. That's all going to be subject to tax, but at least it's not subject to tax twice. Second thing that's not subject to estate tax is gifts to charity. So I have plenty of people, the whole estate goes to charity. They don't owe any estate taxes. And if you chop it up and you leave enough of your estate to charity, you might not owe estate taxes either. So those are two big exceptions to the estate tax situation. But for a lot of people where you're transferring to a non-spouse, non-charitable beneficiary, that's where you run into the tax. And this is how we use trusts to do this, to try and minimize taxes. And this is not a cure-all because it doesn't save us a ton of money, but it's a method that we use to reduce taxes. What we do is we split up a couple, and this only works for married couples. It doesn't work if you're not married. We split up the couple. We give each person their own trust. So each spouse has their own entity, and we try and divide the assets up as much as we can so that each spouse has roughly the same amount of money. And that can be very hard sometimes, especially if you've got a lot of retirement money, because you can't just transfer that between spouses. But if you've got real estate, you can split it. If you've got investments or cash, you can split it. So what we try and do is we try and get people as close to 50-50 as we can. And then when I pass away, my trust is funded with my half of the estate. And it's held for the benefit of the surviving spouse. And typically the surviving spouse is in charge of that trust. So I'm gone and now my wife is in charge of the Eric Prichard Trust, and the Eric Prichard Trust has my half of the estate. And what that does is it shelters the maximum amount I can shelter in Massachusetts, which currently is only $1 million. It would shelter 11.7 federally, but in Massachusetts it shelters $1 million. And so what that means is my wife has her own trust over here. She's got her exemption. When she passes away, the first $1 million in my trust that's been sitting here segregated since I've been gone is not taxed in her estate for estate tax purposes. And that allows us to save some money on estate taxes because we've sheltered $100,000 in taxes by segregating my money when I died. If we hadn't done that, my money would have all gone to her and it would all have been subject to tax when she passed away. It would have all been included in her name, and her estate tax would have been higher. So by splitting things up and funding two separate trusts, we've managed to reduce the estate tax. But as I said, it's not ideal because in Massachusetts, you can only do that with $1 million. And so you're only capturing that initial $1 million when the first spouse passes away. That's your savings. If they ever up the limits, we might save more money. But for now, it's $1 million. And that's better than nothing. I mean, it's $100,000 in tax savings. But sometimes it's not easily done. It's more of a pain in the neck. So it really depends on your situation and how comfortable you are doing something like this before you can jump in and do these kind of trusts. But they do work well. They've been around for a long time, and hopefully at some point the state will raise our thresholds and we'll be able to save more money. But until they do that, this is the system we've got, and that's how we use trusts to protect against estate taxes. So I know we've been here almost an hour because we've had a lot of good questions. Before we go, I just want to point out a couple of things that you really want to keep in mind. The first is you always want to have a will, a healthcare proxy, and a power of attorney. Trusts, maybe not. Wills, healthcare proxy, power of attorney, always. Second thing, which is super important, is check the beneficiary designations on your accounts. If you learned nothing else from this entire conversation, it's that mistakes happen all the time with beneficiary designations. You can check those as soon as you get off this call. Please go do that. And if you see that things are weird, you should fix them after you talk to your lawyer. So those are kind of two huge takeaways. The rest is really, work with a good person that you're comfortable with, get stuff in place, and then you don't have to think about this again for a long time, because generally speaking, it lasts a long time before you have to redo things. So that's kind of my spiel. If there's other questions on the chat, we can answer them. Otherwise, thanks for stopping by and listening.
We do have a couple more questions, Eric, if you have time.
I do.
For those on the call, if you have to drop off, we are recording this and we'll send out a link to that so you can pick up these questions when it gets sent out, hopefully by Friday. So Eric, the first question was just about quick deeds to the house and quick deeding the house to the children. Is there a problem there with capital gains when the kids go to sell it?
Yes. So
Okay.
I don't know how long you want me to talk about it, but if you own a house, so I'll give you a real easy 2-minute example. if I bought my house for $100,000 and now my house is worth $1 million, the $100,000 I bought it for is called my cost basis. And when I sell it for $1 million, I take the $1 million sale, I subtract the cost basis, the $100,000, and the $900,000 that's left is my capital gain, and that's taxed on the sale. So if I gave my house to my kids completely, and I didn't retain a life estate, I didn't have anything else involved, I literally just gave the kids the house. I signed a deed that says, here you go, kids, you own it 100%, no restrictions. When you do that, the kids get your cost basis in the house. So I have just gifted my kids my $100,000 cost basis. And so when they sell the house, they're going to pay capital gains tax on the same $900,000 capital gain as if they were me, because that's what they got with my gift. If I hadn't done that, if I had held on to that house and I had passed away and my kids got that house either through my will or through a trust or however else I get it to my kids, now what happens is they get what's called a stepped up capital gains tax basis. All of that capital gains gets wiped out when I die. And now they start anew with the date of death value as their new cost basis, which is $1 million. And so when they sell it for $1 million, their capital gains tax is zero. They don't pay capital gains tax. Now, it's part of my estate for estate tax purposes when we do that. And so people think, oh, I'm going to get it out of my name. I'm going to put it in my kid's name. And that way it's not in my estate for tax purposes. But keep in mind that the Massachusetts estate tax is between 5 and 10%. Capital gains tax is around 20%. And so if you have a house like I just described with this huge gain, where a 20% capital gains tax on $900,000 is going to be a significant number, it might make a heck of a lot more sense for me to hold the house, pay the estate tax on it at 5%, and now my kids get it without a capital gain. So it really depends on the situation. It depends on how much gain there is in the house. Depends on what else you're trying to do with it. But it can be a real boondoggle for capital gains tax purposes for the recipients of the gift.
Very good. And the last question is, I don't know, I'm going to throw it to you. You can answer it how you like. But just about what it costs. What does it cost to establish a trust?
It totally depends on the situation and the lawyers. I mean, we live in an expensive part of the world, and there are a lot of attorneys who charge a nice chunk to do this. It really depends. I mean, I'm not going to tell you exactly what we charge at Brown & Brown, but if you're looking to do kind of basic work with trusts and you're not taxable, you're looking at least a few $1,000s. And if you're quoted a fee by an attorney of $5,000, that would not be an exceptional fee in this neck of the woods. It's higher than what we would charge, but it's not an unusual fee. I would not be offended by it. Okay. When you get into the tax plan and stuff, and you're dealing with multiple credit shelter trusts, multiple transfers, now you're looking at $5,000, $6,000, $10,000 worth of work, depending on what you're doing. Mm-hmm. Real basic stuff might not be that much. I mean, if we're doing wills, healthcare proxies, and powers of attorney, you're looking at around $1,000 at my firm.
Mm-hmm. That's very good, and you've certainly shown us very clearly how important it is to have someone that knows what they're doing and understands all to do these things. So we very much appreciate your time, Eric.
Yeah, thank you very much.
I will send out a follow-up email